Hey, I'm Nancy Cavey. I'm a national ERISA and individual disability attorney, and I want to welcome you to Winning Isn't Easy. Before we get started, I've got to give you a legal disclaimer. This podcast is not legal advice, but there's nothing that will ever prevent me from giving you an easy to understand overview of the disability insurance world, the games the carriers play, and what you need to know to get the disability insurance benefits you deserve. So off we go. I'm going to talk about three things today, and we're really going to be talking about the wonderful, or maybe not so wonderful, world of social media. First, do your social media posts make you a liar? What every long-term disability applicant needs to know about their social media posts. Two, a federal judge doesn't buy the window tour vacation video that Unum relied on in denying claims and lessons you can learn. And then third, my social media warning that you should take seriously. Let's take a break for a moment before we get started with this episode.
Have you been robbed of your peace of mind from your disability insurance carrier? You owe it to yourself to get a copy of Robbed of Your Peace of Mind, which provides you with everything you need to know about the long-term disability claim process. Request your free copy of the book at caveylaw.com today.
Welcome back to Winning Isn't Easy. Are you ready to get started? Do your social media posts make you a liar? What every long-term disability applicant and recipient needs to know about their social media posts. Look, I've said it before and I'll say it again. Disability insurance companies aren't in the business of paying disability benefits. They will use every trick in the book to deny a claim. And you can be assured that your disability carrier is going to check your social media posts as part of their claims review process. And that's going to happen when you apply for benefits, when your claim has been accepted, and as a tool that they will use to decide whether or not they're going to terminate your benefits at some point. So what you need to know is that what's in your social media post can make or break your long-term disability case. Do you know what's on your Facebook page or the friends who have posted about you, or what's on your LinkedIn profile? You better know. Let me tell you the story of Ms. Malik, a photographer for Associated Retinal Consultants. It was a light duty type of job, and she claimed that she was disabled because of low back pain as a result of moving heavy equipment and because of Guillain-Barré syndrome and fibromyalgia symptoms. So as always, we start with the definition of disability. In the case of Malik versus Unum, which is a Eastern District of Michigan case, the definition of disability was an inability to perform the material and substantial duties of your regular occupation due to your sickness or injury. And then, after 24 months, the inability to perform the material and substantial duties of any occupation. Now, she complained of debilitating pain. She told Unum that her entire days were spent trying to manage her pain and that her pain severely affected her concentration, making most days impossible to read or even research anything. So what did Unum do? Well, guess what? Unum looked at her social media accounts, and what they found was that she was active in researching and writing about radiation issues from at least 2001 to at least March of 2014. In fact, they found that she wrote an article in mid-2012 in which she stated that she maintained several websites to teach people about radiation, mitigation, and other nuclear issues. She was even the host of a show called Nuked Radio, which aired on Tuesdays and Thursdays on Orion Talk Show Network. Now, it got worse because Unum checked her LinkedIn profile, which indicated she had hosted 117 episodes of the radio show between March of 2012 and June of 2013. In January of 2014, she had claimed in one of her articles that she had read over 9,000 studies and research papers in the last 3 years and had a team of approximately 20 trusted volunteers, all of whom who shared common and deeply felt policing concerns about radiation issues. Now it continued to get worse. Malik had a Facebook page. She had founded Rad Chick Radiation Research and Mitigation in the time she was collecting her benefits. Unum checked the group's Facebook page, and that documented over 14,000 likes. Her own personal Facebook page documented that she had hiked several nature trails during the period of time in which she claimed that she couldn't work. And of course, she checked Twitter. They checked Twitter. And her Twitter feed at Rad Chick Forecast had 1,727 followers and 21,100 tweets. So what did Unum do with all this information? Well, they rightfully determined that she was no longer disabled within the meaning of the policy, and they denied the payment of future benefits. Now, Malik continued to play games, and within days of the receipt of Unum's denial letter, she presented on multiple occasions to the emergency room, complaining of pain, muscle weakness, chest pain, confusion, neck spasm, and spells. And guess what? Her physical examination at each one of these emergency room visits was normal, and every diagnostic study that was performed was negative. Now, as you can imagine, after her claim was denied, she appealed, and ultimately this case ended up in court. So the question becomes, how did the court view all of this social media information? Well, to say the least, the judge was not pleased. He noted that Malik's substantial social media activity strongly suggested that her reported symptoms were not as severe as she claimed them to be. The judge rejected her argument that her history of a temporary ability to devote a few hours a week to a podcast and a Facebook page from her bed was not indicative of an ability to hold down a job. The judge even commented that reading 9,000 studies and research papers, hosting 117 episodes of a radio show, managing a team of 20 trusted volunteers, and posting 21,100 tweets to her Twitter account was not consistent with her allegation that she was spending her entire day managing her pain, or that her pain affected her concentration, making it impossible to read or research anything. In upholding the claims denial, the judge found that her social media activity called into question whether her symptoms were as severe as she claimed. And he agreed that Unum had a good reason to deny her claim. So what are the lessons learned? First, don't lie to the insurance company or your doctors about the extent and nature of your physical activity. 2, turn off all your social media. Do not post anything when you decide to file a claim. 3, don't post anything once you're on claim. 4, don't allow your family or friends to post about you or post pictures. 5, you're going to expect that the disability insurance carrier is going to do an investigation of your social media posts, including things like LinkedIn. And lastly, don't expect a court to overturn a claims denial if there's exaggeration or questions about your truthfulness, about your stated limitations. Because if there's a conflict in the medical records and your activity of daily living forms and what you're posting on social media, more likely than not, the court is going to go with what you're posting on social media. Now, I know that social media is a form of curated reality, but it's the nature of the post, the extent of the post, the activity that's discussed on the post in comparison to what you tell the insurance company you can and cannot do and what you're telling your doctors. So don't destroy your claim with a social media flurry of posts or photographs. Let's take a quick break before we head into our next section.